Hi, my name is April Donahauer. Today we're going to be talking about the case of Hamilton v. McDonough, which I argued last week before the U.S. Court of Appeals for Veterans Claims. The issue in this case is what evidence VA must consider when it decides a veteran's claim for compensation for VA medical negligence under 38 USC 1151. A bit of background is useful here. Section 1151 is one of two ways a veteran can recover for VA medical negligence. The other way is by filing suit under the Federal Tort Claims Act, or FTCA. But before you file suit under the FTCA, you must first present an administrative claim to VA, which can decide whether to settle the claim, deny the claim, or do nothing. If VA offers to settle the claim and you accept, you give up the right to sue under the FTCA. But even if you give up the right to sue under the FTCA, you can still file an 1151 claim. If VA grants the 1151 claim as well, it will offset the FTCA settlement against the monthly 1151 benefit. The specific issue here is whether VA must consider the file that it compiles on an FTCA administrative claim that it has settled when it later adjudicates a veteran's 1151 claim. Mr. Hamilton filed an FTCA claim, VA settled that claim, and Mr. Hamilton then filed an 1151 claim. When pursuing the 1151 claim, he advised VA that VA had settled the FTCA claim, but VA did not obtain the FTCA claim file. Mr. Hamilton argued to the Veterans Court that VA should have obtained and considered the file because it is relevant to his 1151 claim based on the same incident. VA has argued that the FTCA administrative claim file is protected by something known as the work product doctrine. A bit more background is useful here. VA adjudicates claims in a non-adversarial system where the goal is granting a veteran every benefit that the facts and law support. On the other hand, litigation in U.S. courts is adversarial. Each side is trying to win against the other. The work product doctrine evolved to protect litigants from their adversaries' efforts to use their own trial preparation efforts against them. It generally protects an attorney's mental impressions from discovery by the other side. Other, more factual materials receive less or no protection. VA has argued that because Mr. Hamilton would not have access in adversarial FTCA litigation to any materials VA prepared in anticipation of that litigation, those materials also should not be part of the file on his 1151 claims. At last week's oral argument, the judges appeared skeptical of the argument that the entire FTCA file is insulated from review when VA is considering an 1151 claim about the same incident. Many of the judges' questions focused on what the proper procedure would be for determining which parts of the FTCA file should or shouldn't be considered. We can expect a decision within the next several months. Thank you for tuning in. For more videos like this, please like and subscribe.